Hello, and welcome to the Three Questions Podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, if you or someone close to you is in a committed unmarried relationship and thinking about updating your estate plan, this episode is especially important. What's our topic today? The three questions unmarried couples should ask before updating their estate plan. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions Podcast, please consider liking this video and subscribing to our podcast and YouTube channels. Across the United States, in particular here in California, the number of unmarried couples living together has grown significantly. Now, many of these couples have built substantial wealth together. They own homes jointly. They have intertwined financial lives, and yet often they don't have the same legal protection that married couples automatically receive. As you could expect, this can cause serious gaps in estate planning, in healthcare decision-making, and asset protection. Without proper planning, one partner can be left vulnerable as something unexpected happens to the other. We're going to address all of that today and more as we explore the three questions unmarried couples should ask before updating their estate plan. And joining us once again, she's almost becoming like a recurring guest now, is Debbie Babb. She is a third-generation Los Angeles attorney, and she specializes in estate planning for complex family dynamics, and we have covered more than a few of those already. And that includes blended families. We did an episode on the Brady Bunches and also high net worth individuals. We did one recently on what happens when you don't communicate properly in your estate plan. So now we're going to tackle unmarried couples. Debbie, great to see you again.
It's so good to be here. Thanks for having me, Wayne.
Yeah, becoming like a recurring guest almost. And I'm going to talk about why partly that is. Every week, without fail, I get an email from Debbie Babb. And it's a newsletter, and I read her newsletters, and her content is excellent. So I got to ask this question. How can someone get on your mailing list?
It's super easy. Just go to my website, dbablaw.com, and I believe the tab is in the upper left corner, subscribe to our newsletter. And that's all.
Yeah. And again, I'm a happy subscriber. I love your content and always a little anecdote about what's going on in your world right away. And then you jump into great topics. And sometimes, I can't quickly enough hit unsubscribe when I get all those emails, probably 3 or 4 times a day, actually, but not yours. Yours I read every time. Okay. So on that note, before we get into our questions, I got to ask this, and I was thinking about this when I was preparing for the podcast. How often do you find yourself advising unmarried couples? Like, is this something that's becoming more of a thing? And I know we were talking about just a couple minutes ago here before we started recording, but is this becoming more of a common thing for you that you're advising unmarried couples?
Absolutely. I think it's close to a third of my practice is now advising unmarried couples and they're in long-term relationships. And sometimes these couples, they've divorced, but they want to continue co-owning the dream of home ownership. And so we're developing plans to take that into account as well.
Okay, I'm going to bring this up. I said I wasn't sure I was going to, but what the heck? Always makes for great when we're impromptu. So I just spent 3 weeks in South Florida. And I was thinking to myself, do you think there's more unmarried couples in Southern California than South Florida? And so I asked you, and your answer was you thought so when we talked before we started recording. You think it's
Yes, I
prevalent here?
do. I do. I mean, I'm not all that familiar
You're
with
not a demographic expert, and it's not your gig, and neither is it mine either. I know that, but
right.
neither one of us. We are
But
completely unqualified to assess this. It's more just an opinion thing.
yeah, yeah.
But you think there are more unmarried couples living together here in Southern California?
Yeah, and then actually, to tie it back to what we're talking about, these unmarried couples in California, it's really important for them to do estate planning because a lot of people don't know this. We are not a common law state. So I haven't looked up whether Florida is, but in California, we are not. So if you are not married, you're not getting the protections under the law for married couples as when
Okay.
it comes to estate planning.
When the rubber hits the proverbial road.
Yeah.
when bad things happen, usually meaning people either get in a car accident, they get really sick, they become able to represent themselves, or they die. Like,
Yeah. I know.
yeah,
It's so
I
sad.
remember. I remember. Was it you that told me one time? I was one. It was. If it wasn't you, it was another one of my SoCal estate planning friends said to me, Wayne. This is what it was. I can't remember if it was you. It might have been you. He said, there is an estate plan. It's just that, who do you want to when to be picked, decide on your estate plan? The state of California or you? Because
Yep.
the
It's
estate
like
plan
the
the state of
state.
California offers may not be what you want.
Right, exactly. Do you want somebody in a black robe making these decisions, or do you want to make your own? Yeah.
Yeah, exactly. So you have all these conversations with your clients, Debbie. What tends to surprise these clients of yours the most when they realize how few legal protections they actually have compared to married couples? Is that unto itself the rude awakening, or
Yeah,
is there anything
and
else?
often it's they're in the hospital and there's been a crisis, and that's when they're discovering they don't have the same protections. Hope, many when they come talk to me, I can alert them, but it's the easy thing to put off talking to an estate planning lawyer. And just, people assume that because they've been together for years, sometimes decades, that they get to be in the hospital room when there's been a crisis. And a hospital doesn't automatically allow the partner to visit or receive updates or make decisions. And so without, the proper documents in place, the hospital has got to defer to the next of kin.
And
And
maybe the next
that's
of kin is estranged.
right.
As if that never
Oftentimes,
happens.
right, exactly,
Yeah.
exactly. Yeah. And then, also what happens when you die without a will or a trust, like we were just saying, your property passes according to the estate plan that the state has put together for you. And your partner doesn't get anything because you're not married. So the state's plan doesn't give anything to unmarried partners. So that can be a huge rude awakening. And by the way, Wayne, all these rude awakenings are at the worst times in people's lives.
No kidding. Yes. So on that note, now I know you get my email every Tuesday morning. Usually it's Tuesday morning. So if you haven't watched it already, I'm going to refer one back to you and to our audience. And it was about a month ago. I had a gentleman who I know really well named Ed Okovich on. Now go back into your emails if you haven't watched this one, or go check your on my website. Ed Okovich is an estate planning attorney out of Toronto. So it was amazing listening to you share about this, what Ed had to say about this almost identical scenarios that he's dealing with now up in Canada. So you want to take a listen to that, or a watch, watch it on my website, or take a listen on your phone, or however, on the same similar situations that he's contending with, almost identical. It's like you guys are echoing each other almost precisely. So that was a good one. Estate planning for Canadians, specifically for people living in Ontario, Canada. But I would encourage you to take a listen, Debbie. I think you might find it educational and informative.
Well, I
Um,
will.
okay, so we are addressing the three questions unmarried couples should ask before updating their estate plan. And so let's get right to it. Why wait? Question number one for Debbie. My partner and I live in my primary residence. I am updating my estate plan and would like to know how to ensure my partner can remain in my home if I were to die before they do. Off you go, Debbie.
Yes. Okay. So this is one of the most important questions I help clients walk through. And the most common approach is to establish a revocable living trust and then transfer the house into the trust. And then the trust can include specific language granting your partner the right to live in the home for a defined period or even for the rest of their life before the property eventually passes to maybe your children or other people you want to name in your plan. Another
And you can tailor that specifically, and it can be pretty precise as to those instructions, right?
very,
And
yes,
the exec and I almost said I did executor. Sorry, that's the Canadian in me. The trustee basically has to abide by those wishes. That's another part I think that people don't realize is the trustee doesn't have a lot of leeway. And they basically have to follow the instructions where powers of attorney is a bit more discretionary, I guess is the word I would use to some extent.
Yeah, I mean, I don't know
Well,
if
when
I
it comes
agree
to
with that,
money, a
but I
power
don't
of
want to get us
attorney,
off track.
yeah, fair enough. Anyway,
Uh,
but
but with the,
I
yes,
digress.
we provide a lot of, it's pretty detailed, giving your partner the right to continue to occupy the property after you've passed. We want to cover things like who's covering the insurance, the taxes, the repairs. What if, there's a terrible fire and the house is not habitable? What are we going to do? So
Hmm.
this, you have got to work with a lawyer on this
100%.
because you don't know what you don't know. So another
Well said.
another option that may or may not be appropriate depending on the relationship and other priorities. So this is definitely something you have to work through with a lawyer. But you could add your partner to title of your property. That's not always a good option, but it is an option. And you might choose to name your partner as a joint tenant, and then there's this automatic right of survivorship, just like a husband and wife co-owning a property. Or you could own as tenants in common. Those are the two forms in California. In other states, there's other ways of holding title. Um, with tenancy in common, the each member of the couple gets a defined share, and then we can say what's going to happen to that person's share through their own estate plan. Each of these options has different implications for taxes, Medi-Cal
Yeah,
claiming.
that's exactly where I was going in my mind when you were saying that. I was like, this is okay. Now I got to call the CPA.
Right, exactly. And so, yeah, like you have, it really is, there's no one size fits all here. But, at the end of the day, without a plan, your partner has no legal right to remain in the home. And one thing I want to mention before we leave this topic, I often have unmarried partners come to me where they do co-own the property as tenants in common. And in this case, I explain that if they don't do any planning, when one of them passes away, that person's ownership interest is going to pass to their blood. And so then the surviving partner now co-owns the property with maybe their partner's siblings or parents or adult children. And it is a big, big mess. And then, especially in the case of relationships not embraced by the extended family, which sadly I see a lot in same gender relationships, this can be a very unwanted result.
Yeah, I and that segues into my question here, from the mouths of babes, maybe a bit, but so the other partner in this example, is there anything that they could do to their estate plan to help ensure that this arrangement that they want? Is there anything they can do at their end on their side of their estate plan they can do to help codify this arrangement, or are they completely hands are tied?
Their hands are tied, but it is important to address it so that the two plans work in tandem together. But it's not like I could put in my estate plan that I have a right of occupancy in my, if I was, in a unmarried partnership, that I would have a right to their ownership, any interest in their ownership. But you do have to make the plans, make sure they're working together, and having coordinated trusts is a really good way of doing this. And each trust should address what happens to their respective assets and who their healthcare agents and financial agents are and how their wishes interact with each other. And then another, in this way, maybe one day you'll have a family law lawyer on to talk about this, but I recommend that both that the partners enter into a cohabitation agreement.
I was going to ask about that. You're actually great minds think alike on that one.
Yeah, and so with a cohabitation agreement, I know you know what it is, but for the benefit of your listeners, that's a legal document that memorializes the terms of how the partners share their home and their finances during their lifetime. So it's providing clarity and that can prevent disputes later, especially when children from prior relationships are involved. So coordination is key. Putting things down in writing is key, and everything needs to work together, not in isolation.
Well, I think I probably said this on this podcast, I don't know, countless times, but those who fail to plan,
Plan
plan to
to
fail.
fail. Yes.
Right on. Our topic is the three questions unmarried couples should ask before updating their estate plan. Joining us once again is Debbie Babb. Debbie is a third generation Los Angeles attorney specializing in estate planning for complex family dynamics, including blended families and high net worth individuals. Okay, Debbie, let's carry on here and go on to our second question. Here we go. My partner and I have been living together for almost 3 years. She has two adult children from a previous marriage. We're trying to decide who should be our agents under powers of attorney. Should it be my partner or should it be her adult children? That's another complex one, Debbie. Your thoughts?
This is a situation I see frequently, and there is no one size fits all answer, um, as usual. But there are some important principles that can guide the decision. First, just so you know, or your listeners know, a power of attorney grants the legal authority to make financial and legal decisions on your behalf if you become incapacitated. It's a significant responsibility, and the person you choose should be someone who knows your wishes,
And you
fail.
trust implicitly.
Yes, that was my, and who you trust completely to
Yeah.
act in your best
That's
interest.
what I was talking about previously, is that the power of attorney does have some discretion there, which is a bit worrisome. If you have
Right.
to,
Although the reason why I slightly disagreed with
you're
you,
allowed to, you're allowed to hedge me on these things, by the
yes,
way. It's okay. It's all good.
just so you know, the agent under the power of attorney owes a fiduciary duty, the highest level of duty to the
Sure.
person who's incapacitated. So, but I understand that something that's said in law or in a document may not always happen in practice.
Yes, in reality.
Yeah. So, anyway, for many of my clients in committed long-term relationships, a partner is often the most natural choice to serve as your agent. They know your day-to-day finances, your bills, your goals, and they're there with you almost all the time. However, we gotta all, no decisions are made in a vacuum here. I always encourage my clients to think about the dynamics involved. And if there's tension between a partner and adult children from a prior relationship, naming the partner as the agent can sometimes create conflict. And in these situations, it's still worth like naming the partner as the agent, but making sure that the adult children know in advance. Clear communication prior to a crisis goes so far in avoiding conflict when a stressful situation arises.
But
And then also, and Wayne, you and I know very well about this, that sometimes clients choose to a neutral third party, perhaps a professional fiduciary. And
exactly what I was going to bring up.
yes, and that
Reading
so
each other's
many,
minds here.
yep, and in so many situations, that is just the best option, right? The professional fiduciaries, this is their job. They know the law, they know what they're supposed to do. This is not like they're doing this on top of their own lives, their own job, their own family, and they know how to do it and they don't
Right.
make
And they
mistakes.
can be they can be compassionate and dispassionate at the same time.
Yes, exactly, exactly. And then, um, the most important thing here is we want to make sure you choose somebody, excuse me, who's actually going to carry out your wishes. And you need to have conversations with people. It is not enough just to put somebody's name in a document. And we always want to name backups in case our first choice is not able to serve. So I always like to have at least two names. If I can get three from a client, that makes me really happy. So,
I was going to ask you if there were ways to structure this arrangement so both the partner and children would feel comfortable. I think, I don't know. I'm thinking the fiduciary could be the sort of default way because that way you're taking it out of everybody's hands and it's an independent party, and that way you have no conflict of interest. And
Yes, exactly. I know. It's often it's the we're especially in California, we're so lucky because we have a very robust population of professional fiduciaries.
yes,
A
it's not like
lot of
that everywhere, as I can assure you, based on my experience. I have clients all over the United States, and not everybody. I ask some people about fiduciaries, and they kind of look at me going, well, we don't really do that here.
right, right. Yeah.
I have a client in Austin, Texas that had moved from Toronto, and they were new, like they didn't really have any ties, and they had a very complex estate planning situation. I had to end up, we ended up getting one law firm acting as the attorney drafting up the estate planning documents. We had to find another attorney to act as the fiduciary, end up as the successor trustee. They actually did it as a part of their, they offered to be the person to play the successor trustee role in the trust. So, but yeah, it's kind of like not everybody, not everywhere has that. Like here, we're kind of lucky that way because yeah, I have that. That's what I have in my with our trust is that we have a fiduciary, and I'm really glad because again, coming up on 14 years living in California now. It's time is passing here, but it's not the same as not being living here all your life, but having people that you're naturally connected with.
Yeah. Yep. And I know often I do have clients that don't have anybody or they're older and all their friends are older and maybe they don't have, maybe their children aren't good with money or they don't have good relationships or
Right.
there's strife among the children and, and
The drama that is families. All right, Debbie, let's move on to question number three. Here we go. My partner and I are living together. Both of us were previously married. I'd like my partner to be my primary healthcare agent. How do I go about implementing that? This is right in your wheelhouse. Take it away.
Yeah, so in California, and all states have a version of this, but in California, we call it the Advanced Healthcare Directive. And this does two things. First, it names the person you want to make medical decisions on your behalf if you're unable to make them for yourself, say you're in a coma. That person's called your healthcare agent. And for an unmarried couple, explicitly naming your partner in a valid healthcare directive is the only reliable way to make sure that they have the authority to make your healthcare decisions for you. Also, and very importantly, in the Advanced Healthcare Directive outlines your wishes for end of life care, things like whether you want to be kept on life support, your preferences for burial or cremation, and your wishes regarding organ donation. And by setting forth your wishes, your healthcare agent now has something in writing from you expressing your wishes and giving the healthcare agent guidance on what you want. And obviously, no document can cover every single contingency. So it's really important to have conversations with your healthcare agent. Um, we it's so important to create this healthcare directive and set forth your wishes. Setting forth agents is really important so everybody knows who's in charge, but also setting forth your wishes is really important because remember, we only are ever going to need your healthcare directive
If
when you
you're,
and your family are in crisis, right?
you're once somebody's incapacitated, usually. I mean,
Right. Right. Oh, absolutely. You are incapacitated before your healthcare directive comes into play. And you don't want your adult children or your parents arguing with your partner about what you would have wanted to happen with your remains or how long to leave you on life support. Yeah, I have seen the relationship between the adult children fall apart because one felt vehemently that their parent wanted to be buried and the other one wanted to be cremated.
yeah.
The other one so and these fights could have easily been avoided
Oh
if
God.
the parent had just simply put down their wishes in a healthcare directive.
Yeah.
So, and then also, without this document, the hospitals and medical providers, they default to the next of kin.
That was going to be a sort of I got questions now. I told you earlier you're like the provocateur. So you just provoked a few more questions. So that was something I was gonna one thing I guess I'll just put out there now. So a what if scenario. You are in a coma and you have your unmarried partner shows up, and then one of your children show up at the same time, and you have no documentation whatsoever, and they both say, "Well, we've been living together for 10 years, you know," and then the child, "Well, that's my mom or my dad or whatever." And now you got doctors trying to figure out what to do here. You're telling me that automatically default if they say that's my parent on the laying there. They're going to default to them no matter what. Is that what you're saying?
Yeah, they go by blood, whoever has the closest blood relationship, and there's no blood relationship. I
Yeah,
mean,
yeah, for
obviously,
sure.
there's a carve out for married people, like
I
that's
get
all.
that, but
Yeah,
assuming we don't, that's not my spouse. It's my unmarried partner. We're living together. All
right,
right.
exactly.
Okay. So this obviously leads to the question: what kind of documents are typically needed to properly name a partner as a healthcare agent? And are there any special considerations when it comes to, HIPAA? Oh boy, or
Yes.
hospital visitation rights? I gotta throw that in there at you too. So chew on that one for a second, Debbie.
Yes. So,
Please.
exactly. So in California, the core document is the Advanced Healthcare Directive. Every state has their own version. In California, this is a statutory form. The legislature came up with it for us, and when it's properly executed, it gives whoever you want making your healthcare decisions, probably going to be your partner making your healthcare decisions for you. And then it also serves as the HIPAA authorization, meaning that your partner can, or whoever you name as your agent, can talk to your doctors, review medical records so that they can make informed decisions for you. I always have my clients also execute a standalone HIPAA authorization, and I tell them to keep this on file with their primary care physician and any specialist they see regularly. So this ensures that there's no ambiguity at all about who can receive information about your care. Sometimes I have clients that want to name people who aren't their healthcare agents to their HIPAA release because if they're in a coma, even though they don't want their siblings making healthcare decisions for them, they do want the siblings to be able to talk to the doctors and get information. Um, and something also for couples where one partner has prior children or a prior spouse who might challenge any arrangements. I actually, for all my clients, I do a nomination of conservator. And so this lets you formally state who you do and don't want to serve as your conservator if any court proceedings ever become necessary. So, um,
So that's and again, that's where we go back to almost again getting involving that third party fiduciary as well, right?
right,
That's what I did. I just
exactly.
basically had the third party fiduciary take on all those responsibilities. I'm just saying what I did. I'm not saying I'm right or wrong here, but I just said, you know what? I don't want my kids. I want these other people. I get hire. You're going to do it and handle all of it. So
Yeah.
that was my take on it.
Yeah, I
Uh,
think for making healthcare decisions, people in generally they try to find somebody in their life that like a friend or
Understood.
a family member, but sometimes we just go to a professional fiduciary.
Yeah, you see the argument that I make is that when I don't want someone who's going to be hopefully upset.
Right, right.
We're going to assume that that's the case, that people are kind of troubled by the current situation. So I'd rather have somebody again who can be compassionate and dispassionate, making intelligent decisions as long as you said, there's kind of a roadmap designed already saying this is kind of what my wishes are given my situation.
Right. And can I give a little public service announcement.
Yes, go ahead.
I do not let my clients name their young adult children as healthcare agents. This is
Precisely. That's my
from,
point.
yeah, and also this is just from my personal experience. My mom died. She passed away when I was 24 years old.
Ooh.
She had been on life support. My dad had to make the decision to pull the plug, and
Oh,
thank
yeah.
God that decision did not fall on me. Carrying that trauma for my whole life and having to
I
make the
was the one who
decision.
decided it was, yeah, thank you.
Yeah,
Great. No
yeah,
kidding. Oh my
right.
Debbie. Yeah, for
Yeah, that's
sure.
just too much of a burden for people to have to carry for the rest of their lives. So, I,
Words of wisdom from Debbie Babb here as we wrap up. Okay, so based on our conversation we've had today, great as always. What's one important step a married couple should take if they're thinking about updating their estate plans? What's one thing they can do here right away?
start the conversation with each other, preferably with an attorney. I hear so often from clients that they're so glad that they don't have to figure out everything alone and that I can help them make these really important decisions and share the various options available. And I think the most common reason unmarried couples don't have a proper estate plan in place is that they assume that they have time or they assume their partner already has protection. And neither of these things are guaranteed.
I
Uh,
can vouch to that last comment about people thinking they have time. I got personal experience with that in my own family, and they didn't. It turned
mm,
out,
yeah,
unfortunately, and
yeah,
it was
it's
very not. It went very poorly,
of course,
sadly,
right,
sadly. Okay,
right.
so for the folks that are listening in here today that want to make sure that their estate plan aligns with their wealth management goals, that's something I have a bit of experience in working with. Um, what is the best next step they should take? So, in other words, they would say, I want to make sure that my financial planning goals and my estate planning goals is there. How would you provide direction there?
I would work with a lawyer who's very comfortable collaborating with the client's other advisors and making sure your
Bingo.
financial advisor is comfortable collaborating with the estate planning lawyer. Like it needs to be a team, a collaborative approach. When you get egos involved and one advisor won't talk to the other, and then the client's stuck in the middle playing operator, it's not good.
Okay. I can say this. We have experience. We've done this, you and I, and it has worked really well, by the way, I will say.
Yeah, we have very
Very
happy
well.
clients, right? Like
Right.
they
We have
feel,
mutual clients and not just a very complicated case and lots of moving parts. And uh, thank God you were there. And I'm really glad that we were able to get all that work done. So on that particular case, so well done. So we got people watching, as we know, on the website. And they're able to see all your contact information under you on the screen here. But we're going to have people in their cars, they're going to be for walks, listening on their iPhones or phones or whatever, that can't see all your contact information. And for those people, how can they get a hold of you? What's the best way to contact you?
yeah. My website is dbablaw.com and my phone number is 424-248-0283. And we're always, me and my team, we're here to help. We believe passionately in planning and we want to do what we can to help people plan and get protected.
Debbie, I want to thank you one more time for coming on my podcast. You're a great guest. I love having you on. You provide great content for me. That's for sure. I'll be keeping, like I say, getting your newsletter and seeing what next you say. That has me, another topic for the podcast. Debbie Babb, thank you very much. Debbie is a third generation attorney from Los Angeles, California. She specializes in estate planning for complex family dynamics, and she does it well. Debbie, thank you very much. We'll see you soon. I look forward to bringing you the Three Questions podcast. I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/ Meet with Wayne. Thank you, and we will see you soon.